General, other than passing an appropriations law, are there any limits on what Congress can do?
So I think at the outset, as your question touches on, Justice Thomas, the term appropriation itself contains some essential requirements. So that term is defined to mean a law that provides for funding and that specifies both the source and the purpose of the funding. That's how an appropriation was defined at the founding. It's how it's always been understood, and that's still how it's defined today in sources like the GAO Red Book, which is Congress's own appropriations treatise. So we think that at the outset, it's not just any old law, but a law that contains those features that constitutes an appropriation. And then I think the question becomes, are there other limits out there on how Congress can structure funding for particular type of activities or government functions? We know, obviously, from the Army Appropriations Clause that the answer is yes with respect to that particular government function. There's a durational limit, and it's based on the nature of the activity because the framers were specifically concerned about having a standing army. But I think the Army Appropriations Clause itself demonstrates that there are not otherwise constraints in the Appropriations Clause that would limit Congress and how it decides to structure the funding.
So beyond the initial, almost skeletal requirements of duration and purpose, there isn't, if I hear you right, there is no other condition.
We don't think that the Appropriations Clause places those limits on Congress itself when it enacts a funding statute. But I do want to emphasize that our argument here also relies heavily on history. And so if you have in mind some kind of funding statute or arrangement that's never been done in all of this nation's history, I think the court could take that into account in a future case. Here, though, we have a specific type of appropriation, a capped lump sum appropriation that's standing for a single agency. And our historical argument is that this is nothing new or unprecedented. All of the agencies I previously listed had similar appropriations.
Is there any role in appropriations that appropriations plays in the separation of powers? It seems that, at least when I was in the executive branch, that Congress exercised appropriation to check the executive branch to some extent. If there is, in this case, what would be, in the case of CFPB, how would that play out?
So I do agree and think that, of course, it's a critical element of the separation of powers that Congress has control over the purse. Our argument here is that Congress has exercised that power. This court, of course, is looking at a statute that Congress itself enacted that set up this funding mechanism for the CFPB, which is similar in kind to the way that Congress has funded other financial regulatory agencies.
You don't think this kind of eviscerates the kind of exacting control that Congress usually exercises in the appropriations process?
I don't, and to the extent that this question is pressing on the annual appropriations as a kind of counterpart here, I think that the question becomes, does the Constitution limit Congress with respect to the duration of appropriations? Is there some kind of implicit limit in the text that the court could divine that means that Congress, in contrast to other laws, which of course can remain in effect until a future Congress acts, is Congress limited in how long to leave appropriations in effect? And there, I think the Army Appropriations Clause does a lot of work, because it's not like the framers weren't aware of this dynamic. They thought specifically about the fact that appropriations, like all other laws, might be continuing indefinite until a future Congress acts, and they were concerned about that with respect to a standing army, but they didn't otherwise seek to limit Congress's authority.